started.
Let me stop. Oh, okay. I was just going to ask you, Mr. Simpkins Walker. As I'm looking at the ballot, there's no numeric number that we attach. Is that correct?
That's correct. You're comparing them head to head, so
Got it.
you'll ask which competitor is better at opening, which witness was better in each of the 3 categories, etc.
Got it. Okay. So otherwise, I think we're all ready to go. Let me just make a couple of statements. I practice in state court and federal court practitioners tend to be much more formal than state court. And I frankly prefer the state court way of practicing because I want you to try your case. I want you to be comfortable doing your case. We're going to allow objections, obviously. And I'm going to allow, we're not going to go back and forth multiple times to parties. If you're making the objection, I would encourage you to state all of your grounds at the outset so that the other side has a fair opportunity to address your point. And then I'm going to come back to you and let you respond to him or her. It's going to be unusual. Like I said, we're going to go back and forth multiple times. More often than not, I'm going to hear your objection, hear the other sides, come back to you, and then I'm going to make a ruling. Normally, I would say feel free to walk around the courtroom, make it your home, but feel free to walk around the courtroom, make it your home. You guys are trying this case. With that said, is the plaintiffs ready to proceed?
Yes, Your Honor, the plaintiff is ready to proceed to trial.
And I think my English was incorrect. Are the plaintiffs ready to proceed? I think that's the better, I think my verb was off. How about the defense? Are the defense ready to proceed?
Yes, Your Honor, the defense is ready when you are.
Okay. Why don't we proceed then? Mr. Joseph, would you care to give an opening statement at this time? Oh, by the way, I apologize. Are there any motions pending before we get started?
Yes, Your Honor, the plaintiff has a couple pretrial matters prior to opening statement.
Please proceed. What do you have?
Firstly, we'd like to state appearances before the court.
Please, go ahead.
Good morning, Your Honor. My name is Joshua Joseph. I'm joined today by my second chair, Ms. Kaylin Dettingmeyer. Together, we represent the plaintiff, Ms. Ethel Marks, on behalf of her deceased daughter, Jessica Marks.
Okay. Let me get the spelling of your co-counsel, Ms. And I apologize, I didn't catch her name. You said it.
Ms. Dettingmeyer. I think it's Detting, and then Meir. Fine.
Ms. Dettingmeyer. Got it.
Yes.
Thank you.
Yes, sir.
Ms. Kerr, would you care to introduce yourselves?
Yes, Your Honor. Good morning, Your Honor. Members of the jury, my name is Chloe Kerr. I'm joined today by my co-counsel, Ms. Kaylee Magno.
Good morning, Your Honor, members of the jury.
Good morning.
Together, we represent the defendant in today's case, Sunny's Rooftop Bar. Now, before we proceed, the defense also has a couple housekeeping matters to attend to.
Great. Let's go back to Mr. Joseph, and then I'll come to you, Ms. Kerr. Go ahead, Mr.
Yes,
Joseph.
Your
What are your
Honor.
motions?
Firstly, the plaintiff would like to constructively swear in all witnesses pursuant to Rule 603.
Done. What else do you have?
Also, Your Honor, the plaintiff invokes Rule 615 to constructively sequester all witnesses barring party representatives.
Sounds reasonable to me. And not hearing for any objection from you, Ms. Kerr, I assume that you're fine with these motions. Done.
Yes, Your Honor.
Additionally, Your Honor, we have a few documents we think might be helpful for you during trial. They're the complaint and the trial orders and stipulations. We're putting a copy of these documents in the chat just in case you don't have them already.
Okay. I've actually seen them, so hopefully the jurors will have access to them when and if needed. So.
Yes, Your Honor. I'd also like to draw attention to a couple stipulations.
Okay.
Firstly, Your Honor, I'd like to point out that there's a pretrial order number 2. This order I'd like to bring it to your attention, and pursuant to pretrial order 2, Judge Pasquarello has granted a motion to bifurcate the case. Today's case will only deal with issues of liability and not damages.
Okay, I assume that's okay with you, Ms. Kerr, and that's an agreement?
Yes, Your Honor.
Okay, next.
Additionally, Your Honor, Judge Pasquarello has also pre-admitted 3 exhibits. Pursuant to pretrial order 11, exhibits 1, 22, and 23 are all pre-admitted and may be used at any time. These are the
Okay.
plea agreement between the defendant and the Los Angeles County DA from 2018, an autopsy report, and a police report.
Okay. Ms. Kerr, I assume you have no objection?
That all sounds right to me, Your Honor. No objection.
Okay.
I'd also like to draw your attention to stipulation 14 and stipulation 15. Stipulation 14 states that Jessica Marks was born on January 20th, 2000, and stipulation 15 states that on March 24th, 2019, Sunny's Rooftop Bar was licensed to sell alcohol under section 23-300 of the California Business and Professions Code.
Okay, since this is a stipulation, I assume Ms. Kerr and her team have already agreed to this, so it sounds good to me. Anything else?
Yes, Your Honor. And finally, we have an exhibit we'd like to use during our opening statement. It's exhibit 2, a photograph of Jessica Marks. We're going to be offering this into evidence during trial, and we have a reasonable belief that it will be admitted.
Okay, why don't we, it's tentatively marked and it's available for use during trial, and I'm sure Ms. Kerr will make the appropriate objection if she has one at that time.
Yes, Your Honor. And with that, the plaintiff is ready to proceed to trial.
Okay. Ms. Kerr, what do you have?
Yes, Your Honor. Just a few more housekeeping matters. First, in addition to Mr. Joseph's displaying of that exhibit, both parties have brought a joint exhibit list with their pre-marked exhibit numbers. We just ask that during the trial that those exhibits retain their pre-marked exhibit numbers.
That makes perfectly good sense to me. Mr. Joseph, are you all right with that?
Yes, Your Honor.
Okay.
Second, Your Honor, we'd like to designate our party representative as the owner of Sunny's Rooftop Bar, Sunny Meta, with the understanding that he'll be present today in court.
Okay.
And lastly, Your Honor, in the case that you can't see or hear either of us, we just ask that you just let us know either in the chat or by unmuting.
Okay. Well, I can see and hear everyone. I don't know if this is the best way to do this, but I assume our jurors can hear everyone. If they can't, please, jurors, please notify our bailiff or notify someone right away. Do you have anything else, Ms. Kerr?
No, Your Honor. With that, the defense is ready to proceed to opening statements.
And Mr. Joseph, I assume you're ready to go. He's standing up, which is the universal signal that he seems to want us to draw our attention to him. Go ahead, Mr. Joseph.
May it please the court. Ms. Kerr, members of the jury, count the drinks. A bottle of wine, 3 hard seltzers, a beer, a round of shots, and a mixed drink. You'll hear today that all of these drinks are what killed a young woman named Jessica Marks. Members of the jury, this is Jessica. She was a kind, fun-loving 19-year-old college student. And on the night of March 24th, 2019, she went to a bar with her best friend, and they ordered some drinks. That bar is called Sunny's Rooftop Bar. And the night they served Jessica, they served her drink after drink after drink. They served her drink after drink after drink until Jessica was so drunk that she got in her car and tried to drive off. Less than 2 minutes later, that car was at the bottom of a ravine. Jessica was dead. Count the drinks. That's why we're in court today. Because even though that may sound like a series of mistakes made by a young teenager, under a California law called the Dram Shop Act, bars are actually held responsible when they overserve underage customers and the customers get injured because of it. Now, as the plaintiff in today's case, we have something called the burden of proof. we have to prove our case by a preponderance of the evidence. But simply, we have to prove to you 4 things more likely than not. First, we have to prove that Jessica Marks was a minor. Second, that the owner of Sunny's rooftop bar, Sunny Meta, served her alcohol. Third, that Jessica Marks was obviously intoxicated when she was served that alcohol. And fourth, after selling Jessica Marks that alcohol, that's what caused her death. Members of the jury, we're going to meet this burden in court today because we're going to count the drinks. Now, to help us count the drinks, you're going to hear from a woman named Morgan Levin. Morgan Levin was Jessica Marks's best friend, and she was with her the night that she passed away. Now, Miss Levin's going to show us the receipt from that night, a receipt that shows drink after drink after drink. Now, when you see that receipt in court today, I want you to judge for yourselves if she could have been perfectly sober. I want you to count the drinks. Now, today in court, Morgan Levin's also going to show you a video taken at Sunny's rooftop bar the night of March 24th. And in that video, you're going to see exactly how Jessica Marks was acting all night. Now, I want you to pay close attention to her behavior in that video and judge for yourselves whether or not that was acting obviously intoxicated. Today in court, you're going to hear that she was. Count the drinks. At the end of this trial, I'm going to come before you and I'm going to count the drinks one more time. When I do, I ask that you hold the defendant liable. Thank you.
Thank you, Mr. Joseph. Ms. Kerr, would you like to give an opening statement at this time or reserve it?
I'll go ahead and give it at this time, Your Honor. May I proceed?
Please proceed.
All right, Your Honor. May it please the court, Mr. Joseph, members of the jury. When it came to life or death, she chose to drive. It's the night, excuse me, Your Honor. Now, members of the jury, you've already heard a lot about that night of March 24th of 2019. Mr. Joseph just got up here and told you that he'll prove that my client is liable for Jessica Marks' death. But members of the jury, today's case comes down to one thing: whether or not Sunny Meta saw signs of intoxication in Miss Marks. Now, today's case is a devastating story about the death of a 19-year-old girl. Today's case is an emotional one that stirs outrage and grief in all of our hearts that a life could be taken so young. But members of the jury, in today's trial, we're going to ask you to set aside that emotion and to focus on the law. Because twice that night, when it came to life or death, she chose to drive. Miss Marks' night started at 8 p.m. She, along with her friend, Morgan Levin, decided to get a few drinks at Sunny's rooftop bar. But before going to the bar, Miss Marks has a couple glasses of wine. Now, Miss Marks is faced with a decision. She can call an Uber to take her safely to the bar, or she can drive herself. In a potentially life or death situation, she chose to drive. They arrive at the bar and find that it's your typical night, your typical Sunday night in Malibu. Business at the bar is slow, and the only employees there are the owner, Sunny Meta, and the bartender, Frankfurt Johnson. They order some drinks, and at the end of the night, Jessica is once again faced with another decision. She can call an Uber, or she can drive herself. When it came to life or death, she chose to drive. And she paid the ultimate price. Members of the jury, Mr. Joseph carries a burden. He has to prove to you, by a preponderance of the evidence, 3 things. They have to prove to you that my client saw the signs that Jessica Marks was intoxicated, that after seeing those signs, they knowingly continued to serve Miss Marks drinks, and that as a result, Miss Marks died. Members of the jury, the plaintiff's case will crumble at that very first element, that the employees of Sunny's Rooftop Bar saw signs of intoxication in Miss Marks. Because today, you'll hear the exact opposite. You'll learn from Sunny Mehta that at no point that night did Mr. Mehta ever see Jessica acting in a way that would indicate that she was intoxicated. Members of the jury, today the plaintiff will fail to meet their burden. Now, today the defense has raised something called an affirmative defense of comparative fault. All that means is that if you find that the defendant has met their burden, we will show that it is more likely than not that Jessica's death was caused by her own decisions. At the end of today's case, we'll ask you to find my client not liable for Jessica Marks' death. Thank you.
Thank you, Ms. Kerr. Mr. Joseph, are you prepared to call a witness at this time?
Yes, Your Honor. At this time, the plaintiff calls Ms. Morgan Levin to the stand.
All right.
Good afternoon, Ms. Levin. Could you please introduce yourself to the jury?
My name is Morgan Levin. I'm a rising senior at UCLA.
Could you tell us a bit about yourself?
Well, I'm pre-med. I want to be a doctor.
Do you know why we're in court today?
I do. About 2 years ago now, my best friend, Jessica Marks, was in a car crash, and I was there when it happened.
Ms. Dettingmeyer, could you please screen share Exhibit 2 constructively out of the presence of the jury? Ms. Levin, who is that?
That's Jessica.
Is it an accurate photo of Jessica?
Yeah, it is.
Your Honor, at this time, the plaintiff offers Exhibit 2 into evidence.
No objection, Your Honor.
Exhibit 2 will be received.
Ms. Levin, I want the jury to get to know Jessica because she can't be here today herself. What was she like?
Well, we met back in middle school. She was one of the kindest, most genuine people I knew. We had the kind of friendship where even when I moved across the country for college, it didn't matter. That was just the way it was with us.
Thank you, Ms. Dettingmeyer. You can stop screen sharing now. Ms. Levin, I know this is going to be difficult, but we're going to have to talk about the night that Jessica died. When did she pass away?
It was March 24th of 2019.
What were you and Jessica doing that night?
Well, we went to a bar in Malibu, Sunny's Rooftop Bar.
Well, I want to take the night step by step. Ms. Dettingmeyer is screen sharing a timeline. What time did you and Jessica arrive at Sunny's Rooftop Bar?
We got there at around 9.
What time did you and Jessica leave Sunny's Rooftop Bar?
We left a little before midnight, maybe 11:45 or so.
Now, between 9 p.m. and 11:45, did you and Jessica ever order any drinks?
Yeah, we did.
Would you recognize a receipt with the drinks that you and Jessica ordered if I showed it to you in court today?
Yeah, I think I would.
Ms. Dettingmeyer, could you screen share Exhibit 17 constructively out of the presence of the jury? Ms. Levin, what is that?
That's our receipt from that night.
Is it a fair and accurate copy of the drinks that you ordered?
Yeah, it looks like it.
Your Honor, at this time, the plaintiff offers Exhibit 17 as evidence.
Ms. Kerr.
Your Honor, as long as opposing counsel is offering this as a business record, the defense has no objection.
Mr. Joseph.
Your Honor, I believe this isn't actually a business record.
Okay. As Ms. Kerr.
Well then, Your Honor, if he's not offering it as a business record, I would object hearsay.
Maybe I misheard him. I thought he said that it was his belief that this was a business record.
Oh, I'm sorry. Then
Did I misquote you, Mr. Joseph?
Yes, Your Honor. It's my contention that this isn't a business record, but I'd be
Oh,
happy.
I'm sorry. What did you say? Did you say isn't or is not?
Is not a business record.
Not a business record.
Yes, Your Honor. It's not a record of regularly conducted business. It's a receipt.
Your Honor, my objection to hearsay still stands.
May I respond?
Sure.
Your Honor, pursuant to Rule 801, these are statements made by a party opponent and are therefore not considered hearsay. Sonny's Rooftop Bar is our party opponent, and therefore this isn't a hearsay statement.
Your Honor, may I be heard?
Sure.
There are several statements on here, everything in blue, if you see, Your Honor, that are not party opponent statements. They are statements made by Morgan Levin.
Okay. So, Mr. Joseph, since you're not offering this as a business record, but you're offering this as essentially an admission, if I hear you correctly, is that what your position is of Sonny's Rooftop Bar?
Yes, Your Honor. That is my position, that this receipt was made by Sonny's Rooftop Bar, and they're our party opponent, so these statements aren't hearsay. And as for the writing in blue, those aren't statements to begin with.
Well, but so if I hear Ms. Kerr correctly, she doesn't seem to have an objection to the part that says Sonny's Rooftop Bar, the date, the number of drinks, etc. But she is objecting to the portion in blue that says gratuity, total, and Morgan Levin. Is that right, Ms. Kerr?
Yes, Your Honor, that is correct.
So-
Everything else is, I agree, a statement made by Sonny's Rooftop Bar, but by Miss Levin writing down the gratuity, the total, and then signing that receipt, that is a statement made by Morgan Levin, not by Sonny's Rooftop Bar.
I got it. Thank you, Ms. Kerr. So, Mr. Joseph, the way I'm going to rule is I'm going to rule that Exhibit 17 can come in before the jury. I'm going to sustain Ms. Kerr's objection as to just the writing in blue.
Yes, Your Honor.
So we're going to pretend, because we're not in the courtroom and we're not going to have access to copying, that when it goes before the jury, the stuff in blue, the writing in blue is going to be redacted out, but everything else can come in. Will that satisfy you for your case?
Yes, Your Honor.
Okay, so that's what we're going to do.
Okay,
Okay, continue.
Ms. Levin, starting at the beginning of this receipt, what's the first drink you and Jessica ordered?
That was a bottle of wine.
And what was the second drink?
Then we had a few White Claws.
And what was the third alcoholic beverage that you and Jessica ordered?
It was a beer.
Did you have any other beers?
Yes, we did. We had two.
And then after that, do you have any other drinks?
We had a green tea shot.
Now I actually want to count the drinks that Jessica Marks drank herself. Starting with that bottle of wine, how much of that did you drink?
I had just one glass and Jessica had the rest of it.
Now moving down to those 3 White Claws, who drank those?
She had all of those White Claws.
And what about those 2 beers? Did you drink those?
I had one of the beers and she had the other one.
And lastly, that round of shots. Who drank those?
Same thing. We each had one.
After drinking all-
Objection 403, Your Honor, more prejudicial than probative. May I be heard?
Sure.
Your Honor, the drinks that we see on the screen are not accurate representations of the actual drinks that Jessica Marks and Morgan Levin shared that night. Your Honor, we have no idea what the jury would think if they saw those drinks and what assumptions they would make based on these animations on the screen, Your Honor. We would ask that if they are going to be presented to the jury, that you reflect to the jury that these are simply representations of the drinks and not accurate reflections of the drinks that were consumed that night.
Mr. Joseph, do you understand your objection?
Yes, Your Honor. May I respond?
Sure.
Your Honor, evidence is only considered more prejudicial than probative when it's prejudicial, prejudice far outweighs its probative value. Your Honor, these are just pictures of the drinks that they drank, and this witness is testifying to exactly what she drank. I'm sure the members of the jury know what a glass of wine looks like and a can of beer looks like. These are solely animations to help the jury understand what Jessica drank that night.
May I respond just one last time,
Sure.
Your Honor?
Yeah, please.
I'd just like to address something that Mr. Joseph said. These aren't pictures of the drinks that were consumed that night. The issue that I take with just presenting these drinks on the screen is that they don't reflect the alcohol content that was in the drinks. And therefore, if someone, let's say, has a hard seltzer and they had it at 6% alcohol percentage, but the seltzers that Ms. Marks drank that night could be 8%. Therefore, Your Honor, the prejudicial effect, the prejudicial effect of these drinks being displayed on the screen is more substantial than the probative value.
Your Honor, may I briefly respond?
Sure.
Your Honor, this goes to weight and not admissibility. If opposing counsel wants to, they can redirect or they can cross on this, Your Honor. They can cross on this point and ask this witness the alcohol content in each one of these drinks. This witness only testified to what she saw Jessica drink, which she is allowed to do as a lay witness, Your Honor.
So let me ask you this. Were you planning on using this chart in front of the jury for closing argument, Mr. Joseph?
Yes, Your Honor, merely to show the amount of drinks that Jessica Marks drank that night, which this witness is testifying to.
So I hear Ms. Kerr's point, and her point is basically that you used animation here, and it can be suggestive when in fact it may not be completely accurate. In other words, you might have used a bigger bottle than a standard sized wine bottle. You may, your hard seltzer may be bigger than the actual seltzer that you ordered, etc. And the alcohol content varies for the wine, the seltzer, the beer, the shot, etc. So it's a little, you're taking a little license, a little license to poetic license in your depiction. With that said, we're going to assume that at the time that you show this diagram, I'm going to give a special instruction to the jury that says that they are not supposed to take anything from these pictures other than the fact that these represent the quantity. 1 shot, 1 beer, 3 hard seltzers, as you characterize most of the bottle of wine. How about that? And
yes, Your Honor.
They're not supposed to assume that the wine is, et cetera, from
Yes.
the. Would that be okay, Ms. Kerr?
Yes, Your Honor, that sounds fine to the defense.
And just to speed the trial along, I'm not going to repeat that when you go to closing argument. We're going to constructively assume I made that special instruction. Please proceed.
Miss Levin, did Jessica have anything else to drink besides all of these drinks?
She did. At one point, she went downstairs to the bar and she came back with a rum and Coke.
Now, after drinking all of these drinks, how was she behaving?
She seemed like she was starting to get drunk. She was slurring her words, kind of stumbling a bit.
Do you know whether the owner of the bar noticed any of Jessica's actions?
I do, actually. At one point, Jessica was coming back from the bathroom and she stumbled on the stairs. And Sunny said, we might need to cut this one off.
Around when was that?
That was at around 10.
I'll let the record reflect. We're adding Sunny sees Jessica trip onto the timeline at around 10 p.m. And you talked about how Jessica was behaving, Miss Levin. Do you have any videos showing that?
I do. I actually took a video of her at around 11.
Ms. Dettingmeyer, could you screen share Exhibit 10, please, constructively out of the presence of the jury? Ms. Levin, what is that?
This is that video that I took of Jessica.
When you reviewed it, was it accurate?
Yeah, it was.
Your Honor, at this time, the plaintiff offers Exhibit 10 into evidence.
Ms. Kerr?
Your Honor, I would object to hearsay.
Can you,
Would you like me to explain, Your Honor?
please, yes.
Yes, Your Honor. The statements made in this video and the video itself are a statement. If opposing counsel is offering this into evidence as the truth of the matter asserted, the truth that Jessica Marks was truthfully acting this way that night, then Your Honor, that's hearsay.
Okay, just to reveal my potential ignorance here. I didn't realize that he was admitting the video. I thought he was just admitting the still that I'm looking at right now. So, but at any rate, the whole video, he's offering the whole video and you're objecting to the contents as hearsay. Mr. Joseph.
Yes, Your Honor.
Your Honor, statements are only considered hearsay under Rule 801 if they're intended assertions. There are no intended assertions in this video. In fact, this video is being offered for the effect on the listener to show that how Jessica was acting that night and the effect it had on the people around her. There are no intended assertions in this video, and therefore no truth of the matter is asserted.
So, Ms. Kerr, if I'm hearing Mr. Joseph correctly, I think what he means is that he's not offering it for the truth. He's not offering it to prove that what she's saying is actually true. He's just offering it, if I hear Mr. Joseph correctly, so the jurors can judge her demeanor or her, whether she's slurring, whether she's saying gibberish, that kind of thing. Is that what you're saying, Mr. Joseph?
Yes, Your Honor, there were no intended assertions in this video, and therefore it can't be considered hearsay.
Whether she's talking about whether Justin Bieber is something or other, that has nothing to do with what we care about. It's just what her demeanor at the time. Okay, Ms. Kerr, what is your response?
Your Honor, as long as the jury understands to not take Ms. Marks's words as the truth of the matter asserted, and it's offered to show the effect on whatever listener Mr. Joseph is offering to show the effect on, the defense is fine with that.
So I'm going to give a special instruction when the video is played saying that they're not to take any of the statements for their truth. They're only to use them for them to assess the demeanor and the behavior of the speaker.
Yes, Your Honor, that's all this is being offered for.
Okay, proceed.
Ms. Dettingmeyer, could you please play the video?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Thank you for screen sharing, Ms. Dettingmeyer. And let the record reflect, we're adding video of Jessica at 11:11 p.m. to the timeline. Oh, Ms. Levin, after the bar served Jessica all of those drinks, did you guys leave together?
Well, we left together, but then I took an Uber and Jessica drove.
Did you see her drive off?
I did. I was sitting in the back of the Uber and her car was right in front of ours. And at first it was fine. She was just driving. And then I remember I looked up to check the song on the radio, and her car started veering to the left, and she went off the road, and her car completely flipped over, and I didn't know what to do.
Levin, what did you do?
Well, I told the driver to stop and got out of the car, and I called 911. I remember thinking I had never done that before. And then the police came, and they told me it was too late. She was gone.
Thank you, Your Honor. Thank you, Ms. Levin. I have no further questions.
Cross-examination, Your Honor.
Please proceed, Ms. Kier.
Good morning, Miss Levin.
Good morning.
I'd just like to tell you how sorry I am for your loss. I'm just going to ask you a few questions, and then we'll get you out of here, all right?
Okay.
Well, first, I'd like to talk about the beginning of you and Miss Marks's night. You first went to Miss Marks's Airbnb, isn't that right?
That's right.
And you got there around 7 or 8?
I did.
And at the Airbnb, you and Miss Marks had some wine together, correct?
Yeah, we did. We each had a glass.
Well, Miss Levin, you actually saw Miss Marks have 1 or 2 glasses, isn't that right?
That's right. 1 or 2. We each had 1 or 2.
And then around 8:30, you left the Airbnb, correct?
That's right.
And Jessica drove both of you to Sunny's rooftop bar for some drinks. Is that true?
She did.
Miss Levin, Miss Marks didn't call an Uber to take you to the bar, right?
No, she seemed completely fine, so I thought it was okay to drive with her.
That wasn't quite my question, Miss Levin. She just didn't call an Uber, right?
That's right.
She chose to drive. Isn't that right, Miss Levin?
She did, yes.
Now, I'd like to talk about the time that you were at the bar. While you were there, you were taking some pictures, right?
That's right. I did take some photographs.
But that night, you deleted 6 pictures from your phone, correct?
Yeah, I think I did. I went back and looked later, and I think I must have deleted 6 photos.
Miss Levin, you have no idea what was in those photos, correct?
No, I think they must have been blurry.
Well, I want to talk about a couple of other things you didn't know that night. Is it true that you don't know how many drinks Jessica Marks had?
No, I know the number of drinks she had. I was with her.
Well, that night, you thought she only had 6 drinks, correct?
That's right. She had 5 drinks and most of a bottle of wine.
But Miss Levin, you weren't even aware that Miss Marks had gotten a free drink until your deposition, correct?
A free drink? I mean, I remember she came upstairs with a rum and Coke. That's right.
But you weren't aware that that was a free drink, correct?
That's right. I didn't know whether she paid for it.
Miss Levin, you have no idea if Miss Marks got any other free drinks, correct?
No, I mean, I was with her when she ordered from Sunny Meta, but otherwise, no, I'm not sure what she was doing at every moment.
Now, Miss Levin, let's talk about those drinks that you did see her order. Now, you don't know if Jessica ever finished her drinks, right?
I don't remember if she finished every drink.
All right, Miss Levin. I'd like to talk to you about what happened after the bar. You left around 11:45.
That's right.
You called an Uber, right?
I did.
You called an Uber because you didn't believe that Miss Marks was safe to drive. Is that true?
That's right. She seemed really drunk.
But Jessica didn't choose to get in your Uber, correct?
Oh, I wish I had tried harder to make her get in the Uber with me, but she didn't.
Well, let's talk about that time that you were waiting for the Uber to arrive. Did Jessica just drive out as soon as you left the bar?
She got in her car and she, pulled out of the parking lot. She drove out pretty quickly after.
Well, Miss Levin, she didn't actually pull out right away. She waited for you, for your Uber to come, right?
That's right. She waited, and then once I got into my Uber, she pulled out pretty quickly.
But even after waiting, even after the Uber arrived, she still chose to drive. Correct?
That's right.
Thank you, Miss Levin. Your Honor, I have no further questions.
Thank you, Ms. Kerr. Mr. Joseph, do you have any redirect?
No redirect, Your Honor. May this witness step down?
Yes, this witness is excused. Thank you for coming in. I assume you don't have any other witnesses, Mr. Joseph?
No, Your Honor. At this time, the plaintiff rests.
Okay. And we'll take up the exhibits at the end, but I assume all exhibits are you can assume all exhibits are going to be admitted unless something dramatic happens. Ms. Kerr.
Yes, Your Honor. At this time, the defense calls Sunny Mehta.
Okay.
Good morning, Mr. Mehta.
Good morning.
What do you do for a living?
Well, I own a bar. Owned a bar.
And what was that bar's name?
Sunny's Rooftop Bar Incorporated.
Well, what did you do to own that bar?
I had to take some classes under the state of California, some training.
And what did that training entail?
Basically, I just had to learn to look for signs of intoxication.
Is that signs of obvious intoxication?
Yeah, it is, yeah.
And were any of your employees required to take this training?
All of them.
And does the state of California require that you retake these classes or exams at any point?
Yeah.
Now, Mr. Mehta, what are some symptoms of obvious intoxication that, based on your training, you would be able to easily recognize an individual in your bar?
Some easy signs to look for would be like bloodshot eyes, red face, slurring's a big one, and of course if they're passed out.
Well, Mr. Mehta, I just want to be clear about something. Does the amount of alcohol that an individual consumes automatically mean that they're obviously intoxicated?
No, it varies person to person, and tolerance is a big factor.
All right. I'd like to talk to you about something that happened in 2019. Do you remember the night of March 24th?
Yeah, I do, yeah.
Do you know who Jessica Marks is?
Yeah, she was a customer there that night.
Mr. Mehta, when did she arrive at the bar?
Around 9.
Did you see anyone else with her?
Yeah, her friend was there.
Do you remember what that friend's name was?
Morgan Levin.
Now, when Miss Marks first arrived, did she seem intoxicated to you?
Not at all, no.
And what happened after Miss Marks and Miss Levin got to the bar?
They settled in and ordered some drinks. I think the first thing they ordered was a wine.
And Mr. Meta, who was serving them that night?
Me.
Now, Mr. Meta, when you were serving the girls drinks, were you sticking around to chat?
No. I have to go around and serve other people here and there. So
You were serving other people. So were you watching Miss Marks that entire night?
no, not at all. So much to do.
Do you recall how many times you served Miss Marks drinks?
I'd say about 8 to 10 times, give or take.
And after each time that you made these rounds, that you served Miss Marks, did you ever see Miss Marks displaying any signs of intoxication?
No, not at all. No, I would have cut her off.
So, Mr. Meta, just to be clear, did you ever see Miss Marks's eyes red or watery?
No,
Did you ever see her face get red?
no.
Did you ever hear Miss Marks slurring her words?
No, not from what I've heard. No,
Did you ever see Miss Marks lose her balance at any point that night?
no,
Mr. Meta, did Miss Marks ever stumble into you on the stairs of your bar?
no. I don't remember anything like that.
So, Mr. Meta, do you have any reason to believe that Miss Marks was intoxicated any of the 8 to 10 times that you served her?
No, she had zero symptoms from what I could see.
All right. Now, I'd like to talk to you more towards the end of that evening. Did you see Miss Marks leave the bar that night?
I did. I like to make sure I see all my customers out.
And about what time did you see her leave?
That was around like 11:45.
Where were you when you were watching Miss Marks leave your bar?
I was at the bottom of the stairs because my customers who go on the roof, they have to walk down. So I make sure to see all of them out.
And when you saw her, was she displaying any symptoms of obvious intoxication?
No, not at all.
Mr. Meta, when Miss Marks left your bar that night, did you have any reason to believe that she would get into a car accident?
No reason.
Thank you, Mr. Meta. Your Honor, I have no further questions at this time.
Thank you, Mr. Joseph. Cross-examination.
Yes, Your Honor. Now, Mr. Meta, on direct examination, you were talking about how you had zero reason to suspect Jessica Marks was intoxicated. But I want to
No.
talk about why that's not true.
Okay.
You and Jessica, you were together all night, weren't you?
Me and Jessica? No, I saw her like 8 to 10 times at most.
Well, you'd agree with me that Sunny's rooftop is a pretty small place, right?
I mean, I guess, but I have other customers I need to tend to.
They're only around a couple chairs inside and then the rooftop space outside, right?
Yeah,
You'd recognize a picture of it if I showed it to you in court today.
of course.
Ms. Dettingmeyer, could you please screen share exhibits 8 and 9 constructively out of the scope of the jury? Mr. Meta, this is your bar?
Mhm.
There are fair and accurate pictures of what your bar looks like.
Yeah, 100%.
Your Honor, at this time, the plaintiff offers exhibit 8 and exhibit 9 into evidence.
No objection, Your Honor.
It'll be received.
And do you agree with me that there were only a couple chairs inside, right? That shows all the chairs you have.
Yeah, that shows everything.
And this is your entire bar.
Counting the rooftop, yeah.
Thank you, Ms. Dettingmeyer. You can stop screen sharing now. Now I want to talk about the night of March 24th. You'd agree with me that that night you only had 2 people working at your bar, right?
Yeah,
It was just you and the bartender, Frankfurt.
yeah,
And you have Frankfurt make all of the drinks, right?
yeah.
Which means you waited all of the tables.
Mhm.
You took everybody's order,
Mhm.
dropped off all of their drinks.
Let me stop you, Mr. Meta. please answer yes or no rather than, uh-huh.
Oh, sorry.
You served everybody their drinks, Mr. Meadow.
Yeah,
You took everybody's orders.
Yeah.
And you cleared the tables.
Yeah.
March 24th, that was a Sunday night, wasn't it?
I believe so, yeah.
And you'd agree with me that you don't get much business on Sunday night, right?
Yeah, but I still have other customers.
Well, actually, on direct examination, you said that you had so much to do, right?
Yeah, I have to seat everyone else, make sure they get home safe.
But at any given time on that Sunday night, there were actually only a couple customers in your bar, isn't that right?
Yeah, couple customers can do a lot, so.
Exactly, and you served all of them.
Mhm.
And one of those customers was Jessica Marks.
Yeah, she was,
You took all of her orders.
I did,
You dropped off all of her drinks.
yeah, I did,
You cleared her table.
Yeah.
Gave her receipt.
yes,
Yet you still say that there wasn't a single time where she was acting at least tipsy, right?
yeah, I would have stopped it otherwise.
Exactly. You think she was sober the entire night.
Yeah, for the most part, yeah.
Well, I want to actually count the drinks that she drank. Like I said, you recognize her receipt from that night, wouldn't you?
I do, yeah.
Ms. Dettingmeyer, could you screen share Exhibit 17, please? Now, I want to start at the beginning of that receipt. You served her a bottle of wine, right?
I did,
And you'd agree with me that you think she drank at least half of it.
probably.
But you were here in court when Morgan Levin said that she drank almost all of it, weren't you?
Yes, I was here.
The next 3 drinks are 3 White Claws, right?
Yeah. Well,
Those
I think two. I think two, if I remember correctly.
Well, on the receipt right there, it says 3, doesn't it?
I thought they ordered. I'm pretty sure, if memory serves correct, they ordered another White Claw later.
Mr. Mehta, I'm just asking for you to testify to what this receipt says. It says 3 White Claws on that receipt, doesn't it?
Oh, yeah, on the receipt, yes, it does. Yeah,
And that's the receipt that Jessica and Morgan, those have all the drinks that they ordered, right?
yeah, it does. Yeah,
So you'd agree with me that Jessica and Morgan ordered 3 White Claws,
yeah, they did.
and those are hard seltzers.
Mhm.
Those
Yeah.
have even more alcohol content in them than beer does, don't they?
Yeah,
And the next 2 drinks are 2 beers, aren't they?
yeah,
And Jessica and Morgan drank those, didn't they?
they did.
And then after that, there's a round of shots, isn't there?
Yeah,
And you served Jessica and Morgan that round of shots, didn't you?
I did serve them.
Thank you, Ms. Dettingmeyer. You can stop screen sharing now. So both Jessica and Morgan ordered all of these drinks from you the night of March 24th, right?
Yeah, they ordered these drinks.
And you think Jessica drank at least half of them.
Give or take, probably. Yeah.
Is that a yes to my question?
Yeah, it is. At least half.
And you know Jessica Marks is 5 feet tall.
Yeah, from what I remember.
You'd agree with me that she has a really small build, right?
From what I remember. Yeah.
And in your experience as a bartender, somebody that drinks just 1 or 2 drinks isn't going to behave as intoxicated as somebody who drinks 7 or 8, right?
Well, everyone has different tolerance.
Is that a no to my question?
Could you say it again?
Somebody, in your experience as a bartender, somebody who's just had 1 or 2 drinks would probably act less intoxicated than somebody who's had 7 or 8.
Yeah,
And Jessica Marks had 7 or 8 drinks that night, didn't she?
she did.
And you know that because you cleared her table, right?
Yeah,
And when you cleared her table, you assume that she drank every drink on that receipt, right?
maybe like half. Yeah,
Exactly. You thought it'd be weird for Jessica and Morgan to keep ordering drinks without finishing the other ones, right?
yeah, a little.
Thank you, Mr. Meadow. I have no further questions.
Care, any redirect?
Yes, Your Honor.
Okay,
Mr. Mehta, Mr. Joseph just went through all of the drinks that were on that receipt. Oh, Mr. Mehta, I just want to make something clear. Just because a person drank 5 or 6 drinks, does that mean that you would know that they are obviously intoxicated?
No, not at all. Everyone responds differently to alcohol.
I'd like to talk to you about what you actually saw. You did say that you were clearing the tables, but when you cleared the tables, did you know for a fact that Miss Marks was finishing her drinks?
No, no. I just assumed, yeah.
Thank you, Your Honor. I have no further questions. May Mr. Mehta please be excused?
Yes, thank you, Mr. Mehta, for coming in. At this time, Mr. Joseph's exhibits are admitted. Ms. Kerr, I don't remember if you admitted any or marked or moved any exhibits in.
No, Your Honor, the defense did not.
Okay. Are we prepared to proceed to closing arguments?
Yes, Your Honor.
Okay.
Yes, Your Honor, the defense is ready to proceed when you are.
Okay, well, Mr. Joseph's going to get the first opportunity. Mr. Joseph, whenever you're ready, please proceed.
Yes, Your Honor. May it please the court. Ms. Kerr, members of the jury, count the drinks. Bottle of wine, 3 hard seltzers, a beer, a round of shots, and a mixed drink. I want you to count the drinks because those drinks are what killed Jessica Marks. That's why we've sued Sonny's Rooftop Bar. Now, as the plaintiff in today's case, we came to court today with a burden of proof. We had to prove that the defendant should have known Jessica Marks was obviously intoxicated and that her intoxication is what led to her death. We have to prove these claims by a preponderance of the evidence. But all this means is that we have to prove our case is what happened more likely than not. Today in court, we've met this burden because we've counted the drinks. Now, something we can all agree on is that Sonny Mehta was actually around Jessica all night. You heard from Sonny himself that he served her all of her drinks, cleared all of the tables, and took all of her orders. How could Mr. Mehta not have known Jessica was drunk when they were interacting all night? In fact, you actually heard that Mr. Mehta was the only server there. On a Sunday night with not that many people at the bar, it's obvious that Jessica and Mr. Mehta would have interacted. But instead of just trusting Mr. Mehta's words, trust tangible proof. Proof Morgan Levin brought us today in court with a receipt. And proof that Morgan Levin brought us today in court with a video showing you exactly how Jessica was acting all night. A video that was taken at Sonny's Rooftop Bar right upstairs, just a couple feet away from where Sonny was working. And I actually want to show you that video again right now.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Members of the jury, after seeing that video, I want you to judge for yourselves how Jessica Marks was acting that night. How can you see this video yet believe that Sonny claims there were 0 signs of intoxication? I want you to judge for yourselves and count the drinks. Well, today in court, you heard Morgan Levin count the drinks as well. And after that, she told you that Jessica was acting obviously intoxicated all night. Jessica was slurring her words, her eyes were bloodshot, and sometimes she wasn't making sense. She even lost her balance. You heard today from Morgan Levin that you saw Jessica stumble and fall onto the bartender. And that was at 10 p.m. At 10 p.m., Sunny Meta made a joke somebody should cut them off, and then kept serving drink after drink after drink. Count the drinks. You also heard from Sunny Meta himself. You heard that in his experience, somebody who had just 1 or 2 drinks will behave significantly less drunk than someone who's had 7 or 8. Someone like Jessica, especially someone who's 5 feet tall with a small build. But Sunny didn't just explain that. He also explained how when he was clearing tables, he knew that both Jessica and Morgan had finished their drinks. He assumed that Jessica had probably drinking half of what was left, that they had finished every single cup. Count drinks. No, Miss Kerr's entire case is based on Sunny Meta's words. I want to talk about some of those words. I want to go back to Mr. Meta's testimony on the stand today. I actually wrote down a few things that he said just to make sure I got them right. He said he was serving a lot of people. He said he had so much to do. But how can that be possible when Mr. Meta admitted that there were only a couple people in his bar at once that Sunday night? And he also admitted that Sunday nights are a lot slower than other nights, and that's why they only had 2 people working there. Count the drinks. After counting the drinks, hold the defendant responsible for Jessica Marks's death. Hold the defendant liable. Thank you.
Thank you, Mr. Joseph. Ms. Kerr, you may proceed whenever you're ready.
Thank you, Your Honor. May it please the court, Mr. Joseph, members of the jury. There's a word I want you to remember: choices. Because that word is at the heart of today's case. Jessica Marks made a lot of choices. Now, let's start at the beginning of the night of March 24th. Prior to arriving at the bar, Miss Marks had already started drinking. Here, Miss Marks made her first decision: to drink illegally. She and Miss Levin then decide to go to Sunny's rooftop bar for some drinks. And here, Miss Marks is faced with a second decision. She can call an Uber, or she can drive. She chose to drive. They get to the bar and they have a few drinks. And here, Miss Marks makes yet another choice: to keep drinking. That night, she ordered all of her own drinks. At the end of the night, Miss Levin closes the tap. They come walking down the bar stairs and out of the bar. Miss Levin calls an Uber, but Miss Marks insists that she drive herself. She gets in her car, turns on the ignition, and makes her final choice. When it came to life or death, she chose to drive. Now, members of the jury, like I said at the beginning, at the heart of this case are choices. Choices made by Jessica Marks. But this case is also about responsibility. Sunny's rooftop bar isn't responsible for Jessica Marks's choices. They're only responsible for not over-serving their customers. What happened to Miss Marks that night of March 24th is a tragedy. A tragedy that all of us feel deep within us. We want to point fingers, put the blame on someone else. But again, members of the jury, this is about choices and responsibility. Miss Marks carried the responsibility for her choices. See, members of the jury, when Miss Marks left the bar, she sat in her car waiting for Miss Levin's Uber to show up. And at any point, she could have turned off the ignition, gotten out of the car, went to go wait with Miss Levin, and get in the Uber. But she didn't. All right, well, when the Uber got there, again, She could have turned off her car, gotten out of her car, and just hopped in the Uber and went home with Miss Levin. But she didn't. In the time that it took for Miss Levin's Uber to arrive, Miss Marks not only made a choice, she continued to make the same choice over and over again and again. She chose to drive. And she paid with her life. Members of the jury, count the drinks. You heard today from Sunny Mehta that the number of drinks that someone consumes doesn't mean that they're obviously intoxicated. Why? Because every person interacts with alcohol differently. Different reactions, different tolerance levels. So, members of the jury, don't count the drinks, count the choices. Today, the plaintiff carries the burden. Mr. Joseph has 3 things to prove to you today. He has to prove to you that by a preponderance of the evidence, that my client saw Jessica Marks was drunk and kept serving her drinks, and that was a substantial cause in her death. This means that they have to show to you that it is more likely than not that Mr. Mehta saw signs of intoxication and by ignoring those signs caused Miss Marks' death. But members of the jury, there's one problem. Today, the plaintiff failed to prove that Sunny Mehta saw any signs of intoxication in Miss Marks. You heard today that Sunny was just the server. He didn't stick around chatting with Miss Marks. He wasn't watching Miss Marks the entire night. No, not even Morgan was doing that. At no point that evening did my client ever identify that Miss Marks was acting obviously intoxicated because she wasn't. My client never saw the signs. And if it's more likely than not that Sunny Mehta didn't see the signs that Miss Marks was intoxicated that evening, then according to the law, you must find my client not liable. At the beginning of today's trial, I got up here and I told you that the plaintiff's case was going to crumble at that first element, that the employees of Sunny's rooftop bar saw the signs of intoxication in Miss Marks. And today, you saw just that. The plaintiff's case failed when they failed to, the plaintiff's case fell when they failed to meet their burden because they can't prove to you that Sunny Mehta saw the signs that Jessica Marks was acting drunk. So because of this, they can't prove that my client continued to serve Miss Marks with the knowledge she was drunk. And above all, they can't prove to you that this caused Miss Marks' death. Members of the jury, Miss Marks' death wasn't caused by the actions of Sunny's rooftop bar, but her own. Because when it came to life or death, she chose to drive. We ask that you find my client not liable. Thank you.
Mr. Joseph,
May I proceed, Your Honor?
you may.
When it came to life or death, she chose to drive. Let's think about what Ms. Kerr is actually saying. Opposing counsel is getting up here and saying that Jessica Marks chose death. Now, Ms. Kerr is trying to blame the death of an innocent 19-year-old girl on her own choices. But there's a reason you can't consent when you're under the influence. The same reason you can't make your own choices when you're that drunk. Jessica Marks didn't make the choice to die. The defendant let her. It was his responsibility to cut her off. The responsibility of an adult. The responsibility of an 8-year bar owner. And it was a responsibility under the law. Now, opposing counsel is saying that a 19-year-old girl is more responsible than a sober bar-owning adult. Now, the only thing that the defense has actually been able to bring to you today is the defendant's words. They didn't use a single exhibit during all of trial. They didn't bring any tangible evidence all trial. But instead of just trusting Sonny Mehta's words, which is all the defense actually had, trust actual tangible evidence. Evidence like the receipt and the video that Morgan Levin showed you in court today. Members of the jury, you saw exactly how Jessica Marks was acting that night. So you can judge for yourselves whether or not that behavior was obviously intoxicated. Now, you heard the defendant say he lets all of his customers out at the bar. But even if he claims to not know how drunk she was, he knew exactly how much she had to drink. And why would you ever let somebody who had all of that alcohol to drink get behind the wheel? Would a responsible bar owner let her drive off? Would a responsible bar owner have kept serving her? No, he wouldn't have. Members of the jury, count the drinks and judge for yourselves. Hold the defendant liable. Thank you.
Thank you, Mr. Joseph. Ms. Kerr, do you get an opportunity to rebut?
No, Your Honor, today I don't have an opportunity to present a rebuttal.
Okay. Wasn't sure. Are we done?